Hello, everyone. Welcome to Cracked with Siobhan Aris. As an artist, there's so much mystery around copyright and trademarking your designs, and it can all feel very overwhelming. So today, I'm talking to a lawyer who specializes in exactly this. Her name is Nicole Swartz, and she's going to clear up some of the misconceptions out there and answer your questions. I won't be making a habit of having guests that aren't stained glass artists, but I really am seeing and hearing this topic everywhere lately, so this is a time out, everyone set down your tools and listen kind of episode. In fact, if you only listen to one episode of Cracked, this should be the one. I also encourage you to forward this episode to any of your maker friends who don't do glass, because 99% of this information is applicable to their work as well. My wish for each and every one of you is that you never find yourself in a copyright pickle, and after hearing this episode, you will have some tools to avoid the headache of a design fight. So, without further ado, join me as I crack it all wide open. Hello, Nicole.
Hey, how's it going?
It's going good. Thank you so much for doing this with me today.
Absolutely. Thanks for inviting me. Happy to be here.
Trademark and copyright is a huge topic in my little glass world, with lots of big feelings, anxiety, confusion. I have seen fights break out. I have seen bullying, public shaming, paranoia, tears. I've seen it all. But what I haven't seen is solutions or much clarity. So hopefully today we can answer some questions and provide enough info to avoid some of these conflicts moving forward. To begin, do you want to introduce yourself and tell us who you are?
Yeah, absolutely. So my name is Nicole Swartz. I'm an attorney. I work mostly with trademarks and copyrights. I started my law firm about 5 years ago. I was in law and then I left to start a skincare company, and I did that for about 2 years. And then I had one of those issues that you were talking about that ended in like tears and confusion, and I didn't get a trademark for my brand name. And so somebody else had trademarked it. I got a cease and desist letter and I had to rebrand the whole thing after 2 years. And it was just like a nightmare situation. And I was talking to a lot of my friends about it, and they were like, no, we don't know anything about trademarks. We don't know anything about copyrights. And so I became like obsessed with figuring this out and with being like, it's not going to happen to me. It's not going to happen to my friends. It's not going to happen to like the business owners that I know, like in small business. So that's really what I do now, is just like try to help people avoid the same situation that I was in before. And so now I run a business called Sprout Law, and that's most of what we do.
Okay, awesome, perfect. That's exactly who we need today. You are the hero of the moment. Before we get started, is there like a legal disclaimer we should say? Like, please do not take a recording of this podcast to a courtroom. That's not how this works.
Yeah, we should say that I'm not your attorney, that everything that we're going to talk about today is kind of like general advice, but a lot of law and a lot of like copyright law is in the specifics of each case, of each design. And so, we're providing general advice, but it's not legal advice.
Okay, great. So let's start with issues that may arise with other small makers first. And then later, let's go into dealing with larger corporations and then the logistics of registering a design with the Copyright Office. First thing, you have a design, you're proud of it, you made it, you love it, and you're scrolling through Instagram and somebody else has copied your design and it is not registered. What's the first thing you do?
You build a time machine and you go back and you register that design. But if it's not registered, then you can reach out to them. But the problem, and why I say you really want to have it registered, is that you cannot sue someone for damages unless you have it registered. So you can send a cease and desist to somebody, you can try to get a licensing agreement, you could try to get a use fee. But if somebody actually looks at it, they'll say like, well, you can't actually sue me. So what do I care if I'm stealing your design? You can get like an injunction and maybe stop the design. So that's like a possibility, but that I think it's usually pretty unlikely in that situation. So if you haven't registered it, it's really tricky. I think you could still send a cease and desist letter and try to have them take it down. You could still, try to send a licensing agreement or a usage fee and try to, at least get some money out of it. But if they were to take it to an attorney, they would probably just tell that other person to ignore you.
At sunbirds_glassart said, where is the line of being inspired by a design and stealing the idea drawn?
Yeah, there's sort of like a rumor that it's maybe 30%, like you have to change it, a certain amount. I usually would say it's more like you've changed 51% or you've added 51% to the original work. The test really, and this is why it's sort of like a case by case basis, is that it has to become a new work that's capable of copyright protection. So it has to be like you've added enough to make it an original new thing. And the line for that just depends on, exactly what situation it is and exactly like what medium it's fixed in and stuff like that. But the test really is like, is it quote unquote substantially similar? And that usually means like it's become a new work. You've changed enough of it so that you could tell it apart, I guess is the best way to describe it.
Okay. And I always say that I think the best thing to do is to reach out to the person, be very kind to start, always open with kindness. It's going to get you further. But let's say you message them and they tell you to F off. At what point, which ones, is there a way to know when you should take legal action and when you should not? Like, is there a monetary amount? Like if they're selling it or not selling it?
If you're just going to reach out in a friendly way and you're not going to take it to a lawsuit, but you know that like you haven't registered it, but you're still going to like reach out and send them a friendly DM and just say like, will you change it? Then, I mean, I guess there's not really a threshold because there's no like downside,
Mhm.
really to doing that. But I think it's still kind of risky because like maybe they'll try to copyright it before you, or maybe they'll try to like, send you a cease and desist letter, which we've seen a couple times happen this year with our clients. So generally,
Whoa.
I would just say like if it's not registered, my thought is like I wouldn't mess with it.
That is so shady. I didn't even think of that as an opportunity, like a possibility that somebody could switch it up on you.
Yeah, and we've had some crazy situations too where people have been like sort of retaliatory. So like somebody sold us somebody else's jewelry design and then like this person started like trying to flag all of their photos as like copyright infringement, trademark infringement, and get all their photos taken down. And like they had reposted their original photos with a new date. And so like it tricked Instagram and Facebook into thinking that their other person's was first. And so people can get really messy with it. And that's why I think that like it doesn't really make sense to get involved in the drama unless you could actually take some action with it and have like a registered copyright, because that's just going to shut it down.
Okay. Interesting. I'm already learning so much.
But I mean,
Okay.
I will say like it's not, as we'll talk about later, it's not practical to register everything. And I think we'll talk later about like what makes this sense to register and what doesn't. But if it's something that's not registered and you still want to reach out to them, like you still can. And sometimes, if that's really what you want to do, you can. Just know that you might be taking some risks in doing that.
That makes sense. Is there anything you can do to protect a design besides register it?
No, not really. Like there's some sort of practical things that you could do. Like you can add a watermark. Obviously, that's going to maybe deter people. You could add a copyright symbol, but that doesn't really deter people as much. I don't think both of those have like no actual legal significance, but they are like helpful practically in protecting a design. You could add a disclaimer like, we take copyright infringement seriously, and you could add something like that, but that is sort of only as helpful as like the people actually want to follow it. So I think those are some practical things. It makes it a little bit more difficult,
Okay,
if you
so
have
a
a watermark.
watermark, yeah, that helps, but it's not the end all.
Yeah,
Okay.
it doesn't actually give you any protection if somebody did want to copy it, but maybe it could deter some people from not copying it.
Okay. At Stained Intentions Glass Studio said, is that old tale true that if you mail yourself a copy of your design, then it becomes legal proof of the date you created it? Is that an old wives' tale?
It is an old wives' tale. The Copyright Office has said that this is not true. And so I think, the best way to show that you've created something is just to have like notes of your work, to take photos, stuff like that. I don't think usually that like the date of creation is really the biggest issue that people have. So typically I think like that's not really going to be something where you need to show like, oh, this is the date, beyond just having like a photo, or, you've published it online, or, something like that. I think that's usually probably good enough. The issue most of the time is like, what is too similar?
Now, let's say you have a design that is registered and you go on Instagram and some fool has made your design. What's the first thing you do in that scenario?
I think the first thing is like you look at the designs, you make sure that they're actually similar.
Mm-hmm.
And if you're not sure, maybe this is a situation where you reach out to an attorney to see if it's too similar or not. But if it is too similar, then you would reach out with a friendly version of a cease and desist letter. And you could send this, usually we'll send it like via email, but if you wanted to send it via DM, you could do that. If you wanted to send it via like hard copy letter, that's fine too. And just kind of reach out and say like, this is my registration number. There's some legal language that you want your cease and desist letter to have. So, kind of make sure it has those things. But usually I will give people 30 days to respond to that, and either to take it down or to, come back with a response. And then if they haven't responded in that time period, then I would send the more scary cease and desist letter. Again, I usually give people 30 days, but if you want to give people 14 days or something like that, 7 days, whatever, that's totally fine. And then if they haven't responded, you can, that's probably when you would want to bring in an attorney to like handle it. Usually, an email from a law firm is going to be helpful if it's a small business, but if it's a larger business, then maybe you need to get a law firm involved to look over your case for infringement. So I think that's generally what I would do.
So the cease and desist letter is something that you should just find like a template for online before you should do that letter, the first letter, by yourself before you contact a lawyer. And then if they don't respond the nice way, then you call the lawyer.
Yeah, I would say that's what you do if you're certain that it's actually like similar. Like if it's the exact same work or it's very similar to your work, then you could go ahead and do it yourself with a template that was, I would say, a cease and desist template that's like written by an attorney that has, the legal requirements. I think that's fine to do by yourself.
Okay.
I would say if you're not sure whether it's too similar or not, though, I would check with an attorney before you send out the letter.
So what if you have somebody reach out to you, another small maker, and ask to use your design but pay a use fee?
Yeah, I think that's great as long as you're cool with it. I mean, if you want to do that, then that's great. You should probably have a short contract written up for that. So keep in mind whatever that use fee is, that you're going to want to pay an attorney to draw up a contract. So make sure that use fee covers the legal fees involved in actually drawing that up, to make sure that you get paid for it, to make sure it's structured the right way, to make sure that you keep your copyright rights in the design. So you could either put that on them to like provide the contract and maybe just have an attorney review it, or just make sure that like if you're charging like $100 use fee or something, that like that's not going to cover a contract to even like do the use fee on your part. So just make sure that your use fee is, I would say at least like $300 to $600.
And time limits?
So like you would let them use it for a specific amount of time
Mm-hmm.
on Instagram.
Yeah, like would that be part of that contract? Is that yes, you can use this design for like a certain amount of time and then you can't use it anymore?
Right. Yeah. I think the issue would just be, figuring out what the time is going to be. Like, so is it a month? Is it 6 months? Is it a year? But then also like what happens to the photos and stuff like that? Like, can they stay on your feed? Can you still promote them via highlights? Like after that time period, how does that work?
Okay, so make sure you include those things.
Yeah.
I thought of it because when I send people releases for the podcast, all of the generic releases that I read always say, I have the ownership of our interaction, your likeness, and I can use it for forever. Like there's always that little piece that says how long I can use it for. And so I was thinking maybe that's also something that should be inserted into this kind of a contract as well.
Yeah, definitely. Yeah. Or, if you do want to let them use it forever, then that's fine too, but that's going to be a lot more expensive than letting them use it for 6 months.
Right. Exactly. Should you use how much you think they're going to make off of the design to calculate how much you're going to charge them?
Yeah, there's a couple different ways that you can do it, but I think that should be part of it. You could get a percentage of their sales from it if it's something that they're going to be actually making money off of. If it's something that they're going to be doing as more like advertising or something like that, um, then you could just do like a straight fee. But I think giving yourself a percentage just ensures that, like, even if your calculations are wrong, that you're still, actually making money off of it when
That
they
makes
make money
sense.
off of it. Yeah.
That makes sense.
And I've seen for percentages, like I've seen that from like 3% up to like 15% just based off of the situation in the industry. So I would say like somewhere in there is probably a good range.
It's a sweet spot. Okay, so now we're going to move into a corporate company situation. So you get onto Instagram and I don't want to name a specific company, but a big one has used your design, is now sourcing people in a different country to make tons and tons of them and make tons of money. And it's not registered. What's the first thing you do?
First thing you do, whether it's registered or not, is to reach out to an attorney in this situation. I don't think it's a good idea to go it alone, just because as we're sort of talking about, like, copyright law is hard, it's complicated, it's case by case situation. And the big companies have attorneys whose job is just to sort of screw you out of a copyright. So don't try to like go up against their like attorneys whose job is just to take it from you. Like, hire somebody for your own thing. Like, I wouldn't reach out to them. I wouldn't report it as copyright infringement. I would not try to DIY that situation at all.
If one of my designs is not registered and a corporation steals my design, is it going to be harder for me to find a lawyer to take it on with me?
It depends on a few things. There's, I think, as we'll talk about in registration, there's like maybe one small situation that you could still register it. So if it's within 3 months of when you first published it, you can still register it and still get statutory damages and attorney's fees and stuff like that. So if it's within that 3-month period, then you can still do it. Beyond that, I think it might be hard because you're not going to get attorney's fees, you're not going to get statutory damages, so you're just going to get proof of how much they actually made in profit, and it's just a harder case. So I don't think it's impossible, but I think it's probably a little bit harder. But you can also just pay, you don't have to necessarily like take it to court. You could also just pay an attorney to just check in and be like, what is my case? Like, how does it look? What are my options? So I think even just having that initial conversation would be good. You're not going to have trouble finding an attorney to just like talk with you and figure out if you have a good case or not.
Right. Say a company has taken my design that is not registered or is registered. Let's go both cases. They're selling a lot of them, and I'm actually not that mad about it. And I think, you know, could I license that design if the infringement doesn't interfere with my clientele?
Yeah, absolutely. Yeah. I think that's kind of the same situation. Like, you'd probably approach that the same as if you were upset about it. You kind of want to go into it pretending like you're really upset about it. And then you can back up a little bit, after you say, like, this is a huge copyright infringement, that we want this much money. And then you can sort of back down a little bit and say, like, okay, actually, we're willing to license it. And that's usually like a good sort of way. If you start at 100, then you can sort of negotiate down to like a licensing agreement. But you kind of have to go into it saying that like you're going to sue their pants off. If you go into it saying like we just want a licensing agreement, it could still work, but I think it's a less strong situation.
Okay. And that applies to if it's registered or if it's not registered.
Well, you'd have a better case if it was registered, because if it was unregistered, they might just say like, no, we might just ignore you because we know that you can't sue us.
And is there a standard rate for corporate licensing?
Um, that's kind of the same thing where I've seen it from like 3% if it's like a large company. Um, like a Warner Brothers or something like that is usually about 3% to I've seen it go up to like 12 or 15 in certain situations. So I would say somewhere in there still.
Okay.
And that's again like a situation where you want to figure out like what is the territory that's being licensed? Are they able to use it, just in one country or in a region or in the entire world? For how long is that going to last? Usually there's an annual licensing fee, and that's like a flat fee plus a percentage of the products or services sold.
Okay. All right. So let's dive into actually copywriting your designs. At Interloop Glass said, how do we not go broke doing this? Is it necessary for all original designs?
This is a really good question because the copyright process is kind of frustrating in terms of how many, thinking about how many photos and how many designs and how many creative works of art we all have now as we are artists, as we run our business, like anything. And so technically, there's sort of two routes that you can go. Like one route is you have to register as an individual work. So each individual work that you release has to be its own copyright, which is really frustrating, expensive. You obviously you're not going to register everything. There's another route that you can do where you can register things as a collection. So if the first time that you've released a work, it's sort of there's more than one. There's thinking about if you release it as like a bundle or something the very first time and you sold it as a bundle, you could technically copyright everything in that bundle as one thing. So that's an option to do. It's not going to work retroactively for things that you've already released, but maybe it could be a workaround for things in the future. You release things as a bundle first, and then you could copyright the whole thing.
But you have to sell it as a bundle?
Yes.
Okay.
The very first time that it's offered for sale.
Interesting.
Yeah, then you could copyright it all as one, but then there's some downsides to that too, because now what is substantially similar to that collection, if they take out 4 pieces of work and they're just copying one, now they're just copying 20% of the work. So there's sometimes when it makes sense and there's sometimes when it doesn't, but I would generally say focus on the money makers, focus on the best sellers, the things that make the most money, and register those, and focus on the things that you feel like maybe are upcoming trends, or you feel like this one gets copied a lot, stuff like that.
Are there any designs that can't be registered?
Yeah, there's a lot of designs that can't be registered, unfortunately. So for it to be copyrightable, it has to have what they consider like a modicum of creativity, which I think is like kind of a rude phrase to say this work doesn't have a modicum of creativity. But so basically like variations of colors, variations of fonts, short phrases. That probably doesn't really apply to most of your listeners, but things that are just like they don't have that much design to them. So like very simple designs. The outline of a flower, like just things like that are, not to say that's not beautiful, but they just don't consider that to have like enough creativity in it to differentiate it from other things.
Got it. So it's still kind of a gray area, a little bit.
Yeah, a little bit. I think most designs probably fit in the copyrightable like definition, but for some like simple things, short phrases, if it's a variation of somebody else's work and you've just changed the colors, or you've just changed like the style a little bit, that's not going to be copyrightable. The way that you've like sort of organize things and the way like the layout of things like that can sometimes be an issue. So I think generally it's okay, but if you're working with like very minimal art, then I think it might make sense to check with an attorney to make sure that it's copyrightable before you file it.
Okay. Is it possible for you to walk us through the process of doing
Yeah, I
that?
can just sort of walk you through the general process.
Yeah.
Okay, and knowing that it's going to be different for different people and everything like that. But so you'll go to copyright.gov, and that's the US Copyright Office. And then you'll go to like file a copyright. You might have to like create a login or something like that. And then you'll go to file a new application. Then you'll have to list the type of work that you're protecting. And so it's really important to be accurate here, but you can pick like visual arts, you could pick literary arts. I think maybe, yeah, I think maybe photographs is a separate thing. There's maybe like 8 to 10 different categories. I think for most listeners of your podcast, like works of visual arts probably encompasses it, but you'll just kind of want to pick the the style that most of your work fits into. So even if your work has like text in it, if the majority of the work is not text and that's not how you categorize it, then you wouldn't pick that one. And then you'll go in and you'll put the copyright owner, you'll put like who created this work. You'll have to list if it's a work made for hire. And then you'll have to put the date that it was published, the date that it was created, the country that I believe it's the country that you published it in. And then you'll have to pay the copyright fee, and then submit like a photo or something like that of your work. You don't have to actually like mail in the hard copy, but just like a photo of it usually is good. And then you file it with the Copyright Office. Technically it's official when you first file it. So you can kind of like start using it and like assuming that it's good. But then it's going to take them about like 3 to 6 months to like actually review it and get you a registration number.
And where does the 3-month retroactive apply?
Oh, so okay. So if you register it before somebody infringes on it, that's sort of the general rule, is like you need to register it before somebody copies you in order to get statutory damages and attorney's costs. But there is an exception to that, which is that if somebody has infringed on your work, but it's within a 3-month period from when you first published it, then you can still you could register it after infringement.
Okay.
If that makes sense. It's sort of like a weird exception, but yeah, so within 3 months of publication, otherwise it has to be before somebody has copied you.
Okay.
And you might still have a case, even if you register after that, but it's going to be harder because you don't have these statutory damages. You have to like prove more things and stuff like that.
How long do some of these play out?
Oh, like a copyright infringement situation?
Yeah.
It could be like 1 to 2 months, or it could be like 3 years if you really were to like take it to court.
Right.
So I would say most of them, 90% of them don't actually go to court. So I would say that most of them are going to take 2 to 3 months to resolve.
Okay.
So yeah, it's going to take like 3 to 6 months for you to get your actual copyright. I've actually got one randomly on my desk here, but it's going to take that long. And then you can actually go ahead and start sending out cease and desist letters as soon as you have filed it, even though it's not like approved yet. They sort of give you this grace period. Yeah, and then you can kind of actually start protecting it.
So you don't have to have a lawyer to register something.
You don't have to. No, you could register it yourself. But I think, given what we've talked about registering versus unregistering and how important it is to make sure that it's registered, especially if it's a large company that steals your work, you're going to want to make sure that you've registered it properly and that you've picked the right category, that that everything about the registration is correct.
So this is from @Theodore Ellison Designs. If I register my designs online through the Copyright Office and I make a mistake, will that impact my case if I were to go after a company? It's my understanding and experience that the first line of attack is in the details of the registration itself.
Yeah, I think that's correct. I think it's really important to make sure that you have a registered copyright, especially if it's a large company that steals your work. But even if it's a small company, like small companies now, small makers now are getting like, they're not hesitating to bring in lawyers, and they're not hesitating to like try to attack everything that people are doing. So I think making sure that the registration is correct is very, very important.
So what happens if there is a mistake?
Then they'll try to cancel your registration and try to say it's not actually registered. Or, maybe it's registered, maybe you pick the wrong category and you're not actually registered as a visual work. Maybe you're registered as like some other type of work. And then, any like little mistake, they will try to use that to say that your registration actually isn't valid or that it's not covering the right type of work.
Is it expensive to get a lawyer to help you do it?
To help you copyright it? No, it's usually just a couple $100s.
And how much does it cost to copyright the
It
actual?
depends. So if it's sort of weird. If you're registering it as a sole proprietor, then it's usually around $45 a design. If you're registering it as a company and you want the company to own it, then it's $65.
Oh, that's not bad.
Yeah, it's not too bad, but it is like per design. So that's kind of where it adds up.
Right, but I think
Yeah.
most of us think it's like hundreds of dollars to register a design.
Yeah, it's actually pretty cheap.
That's good news. At Z Hebert 242 wants to know, is there a statute of limitations on copyright?
Where copyrights do expire, if that's what you mean. So usually it's like, not to be morbid, but it's like the author's death plus 70 years. Or if it's a company that owns it, it can go up to like 120 years. So that's how long your copyright is good for. But if you mean like a statute of limitations from like, somebody stole it, like how long do you have to make a case for it? It's just kind of going to depend on like, is it registered? Is it unregistered? And stuff like that.
What's the legal definition of authorship? How would I be able to prove a design is mine?
I don't know the like technical, word for word definition of authorship, but I know it has to just be independently created by a human individual, like a human person. So I think the best way to prove that it's yours is just to, again, like take notes, take photos of the work in creation, and then like being able to show it on your website, on your Instagram, things like that can help prove that it's actually yours. I don't think that authorship is usually the biggest issue. So I don't think that usually they're going to say like, oh, this is actually yours. You didn't actually create it. That's usually kind of assumed. But if you did want to just make sure that you had authorship of it, just take photos, post it in your stories, stuff like that. Or even if you don't want to like publish it, just take photos on your phone.
Just like a timestamp.
Yeah,
somewhere.
exactly. Yeah.
Okay. This is from at Tree Glass Studio. She wants to know, what should new glass artists do to get set up properly with copyright? Do you, Nicole, have a package to download?
I have a lot of blog posts about it. So if you go to sproutlaw.com, click on the blog and scroll down to copyright, we've got everything from like, how do you register copyright to like, when does it make sense? Like what types of work, how do I stop somebody who copied me? All that kind of stuff. So head to the blog. There's a lot there.
Okay, great. And what's your website? Where's the blog?
Yeah, sproutlaw.com.
Okay, great. And at Brewer and Mar said, which category would glass fall into, i.e. sculpture, 2D, etc.?
It's just going to depend on like, what's the key component. So I think, each glasswork could be a different one. Some of them could be visual, some of them could be sculpture, some of them could be 2D, just depending on like, is it a window? Is it a vase? Like there's different ways of what it could be. So I think focusing on like, what is like the main component of it?
Is that a part of the copyright though, where there could be a mistake? Is that a very important, difference between
That's
sculpture
the
and
first part I
2D?
was talking about, where they give you, let me log in really quickly and see if I can look at the categories. But that's the very first part of the process that I was talking about, where they give you like, is it a textual work? Is it a visual work? Where you want to be really careful about how you describe it.
Right, because let's be very specific about what category it should be for stained glass, which would be like something you hang in a window, like a sun catcher or a transom, or something that is not blown glass, not a vase.
I mean, it's going to depend too, though, on, is there text involved in it? Is there like, it's going to be different for everyone. I think most of them probably are going to be visual arts works, but I couldn't say specifically that would be true, because that'd be legal advice and I would have to base it off of like the actual the work itself.
Okay.
So the options that you get are literary work, work of the visual arts, sound recording, work of the performing arts, motion picture / AV work, or single serial issue. And then I think that there might be a section at the end of the process when you, again, kind of have to like describe what it would be. And that's probably where you'd want to work with an attorney to figure out like what category is my work in, because it's just going to be, it's just going to depend on like each individual work.
Okay.
But I actually, I'm going through the application now. I don't think that, I don't see another section where you'd really have to list that. There is a section where you would want to, if you want to like limit your claim to exclude things or include new material based off of an old copyright, but that's probably not something that applies to most people. So again, like that's kind of where I'm like, I would probably hire an attorney if you're looking at that page and trying to figure it out, because that's a page where you could easily, if you're trying to figure out like which one of these should I select, you'd actually be limiting your copyright to remove those key points. So you could actually remove the most important part of your work from the copyright. So I would say like maybe this question sort of making me like nervous about people DIYing it, because I don't want you to like say, oh, I would be 2D artwork, and then actually like you're taking away all the 2D artwork out of your copyright.
Right.
If that makes sense.
That does make sense.
Okay.
So disclaimer, call a lawyer.
Yeah.
Call
Yeah,
Nicole.
I think visual arts work is probably appropriate generally, but if you have questions beyond that, yeah, I don't want you to mess it up.
Okay. I don't want anybody to mess it up either. What's the biggest mistake you see being made when people try to register a design?
I think the biggest one I see is just people not registering it. And then like somebody steals it, and then especially if it's like a large company, and then it's really tricky to get, to be able to like fight them on it, because they already kind of know, they're already prepared for it. They already have attorneys who are like ready to say you're not registered and stuff like that. So I think the biggest mistake is just not registering at all, and like kind of waiting until somebody takes it.
What if somebody accuses you of stealing and posts on Instagram about you and on their stories and does a whole thing very publicly, and you feel like you didn't steal their design? Do you have any rights? Can you do anything at all about that?
Yeah, this is like a real thing that gets messy. That's technically defamation if you didn't steal it, and then people are calling you a thief and they're saying that you're, stealing their work, then they're technically defaming you. So you could have a defamation case against them for saying that. But yeah, so I usually would advise people, like if you're in the opposite situation and you feel like somebody stole your work, be very careful about the language that you're using. Like, don't say somebody stole my work, but you can say things like, this work looks very similar to mine, because that's not like making an accusation. So I think just like when you're on the flip side of it, be very careful about how you're talking about the other person to make sure that you don't have a defamation case against you.
And if somebody is posting about you and you're like, whoa, 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 should you reach out to them directly?
Yeah, I would reach out to them directly. And, again, like I think kind of reading the situation, I always like to start off nice, but maybe if somebody is like really going at you, maybe it's best to just like, come on strong and say like, you post again, like we're filing a defamation case, or we're going to look into defamation, or, like I think if you're looking to hopefully end it quickly and maybe scare them, coming on strong with like, we're going to get our attorneys involved, we think we have a defamation case, like I think that usually will hopefully try to kind of stop the posting. And then if it does continue, you could reach out to an attorney and have them send a letter, because that usually does scare people, like an email from an attorney's office. For most smaller businesses, that will be like enough to make them stop.
And how much does it usually cost? Is there like a average price just to have something like that done from a lawyer?
Yeah, I would say like maybe $300 is probably the price for that.
Okay.
I don't know if
And
that's average, but that's kind of just like what it would be with our firm.
And that applies to really any kind of defamation. If somebody is publicly posting about you, it doesn't have to be that specific scenario. It can be anything where somebody is shaming you publicly.
Yeah, I think anytime when somebody's saying something about you that's not true, and they're saying it in their stories, they say it in a comment on Instagram, they say it, to other people, then yeah, that could be a defamation situation.
What if it is true?
Then it's not defamation anymore, but it could be some other things depending on what state you live in, depending on stuff like that. If it could be like publication of like private facts, or it could be like invasion of privacy, it could be false light, like maybe they're portraying you in a false light. So there's some other things it could be. That's probably a situation. If it is true, maybe you want to reach out to an attorney and look at some of these more creative things that it could be.
Okay. I see that all the time.
Really?
Yeah, I see, these situations play out on Instagram. And I think what happens sometimes is that people feel like their hands are tied because they don't have a lot of legal right, but they're frustrated and they're angry. And so they take to their stories. And as much as I want to make a bowl of popcorn and pull up a chair, it's hard to see. It's hard to watch because it's like, there's no place for it on Instagram as far as I'm concerned. And it's tough. It's tough to watch because there's always one side that's getting pummeled by the other.
Yeah, and usually it's a situation where like the person who is lashing out on social media like really just needs to call an attorney and
Mhm.
and have it handled that way. Or maybe they have called an attorney and they've realized that like they didn't take care of the legal stuff, and so they don't have any legal rights, and that's why they're lashing out. But usually it's just not a good situation. It gets so messy.
Is there anything else that I missed? Is there anything else about, copywriting, corporate companies, small makers? Is there anything in any of those categories that you feel like is very important for people to know that I missed?
Yeah, I think one thing that could be helpful to talk about is like publication. So this is like a part of registering a copyright is you have to show that you have published the work. And so this usually means that you have distributed to the public for sale, or you've distributed to the public for like a public display. So you've put it on your social, you've put it on your website. I think or you've actually like sold it. So these all kind of depend on the situation, and like sometimes putting it on your website is not enough, sometimes it is. But for something like artwork, I think that or something like glasswork, I think that that's like a public display. It's like your website is like your gallery. So I
Mhm.
think in that sense, like it could be publication. But that's a really important part because that's you want to make sure, again, like you get that date right, of like the first date that you published it, the first date that you put it out for sale, the first date that you put it up for public display. So that's an important part of the process too.
Thank you for that. The last thing I want to ask you about is fan art. I got a lot of messages about this, and so I'm not going to ask anybody specific question. Let's say you love Looney Tunes and you want to make a piece in honor of that. Should you be nervous? Is that legal?
Yeah, a lot of different factors. I'm actually going to look at these factors right now because I think there's maybe 4 or 6 of them, but there's an exception for something called fair use. And fan art kind of toes the line of this, but it's basically like if you're using the work for like some sort of like discussion or criticism or critique, thinking about like what SNL does. It doesn't always have to be a parody, but it can be like something that's newsworthy, or you're using it to like say something about the work itself. Then that can be an exception. It's a little bit harder if it's something that you're selling. One of the factors that they like for fair use is that it's non-commercial use, but you can still do it if it's in certain situations, if you're something that you're selling. So that could be one thing. But I think the biggest thing is like, are you using a little bit of the work? That's good. Are you like, using it to say something? Is it like actually a work of art that it has a point of view and it's offering a critique on something? Then that's usually better. And then I think the third thing is like, knowing who you're dealing with. So like I'm trying to pick fan art that is not particularly litigious. So like don't do Prince fan art because Prince notoriously like takes everybody down. Don't take like Dr. Seuss fan art, like they're very litigious. Like Disney likes to send people cease and desist as well and take things down, but there's just like so much Disney out there that they obviously can't like take everybody down, but I know that they do have people actively working on that. So like try to pick companies that are maybe not as litigious as others.
And is there a difference between if you're selling it or if you're not selling it?
Yeah, it's better if you're not selling it. Like it's better if it's you know, an advertisement or an Instagram post, but it's not like a product that you sell. If it's a product that you sell, then it has to be, you know, it has to have more of those factors, like, you know, you're not using as much of it, or you're using it for like cultural criticism or something like that. It's harder if you're selling it, but it's not impossible.
What if what you're saying about the characters is just that you love them? Is that enough?
Let me look up like what they actually, the actual like terminology that they
Okay.
use. I think one of the things that's really important is like, you know, the companies that are litigious and not. So if it's a company that, you know, they love fan art and they really appreciate that, they don't take those down, they view that as like good advertising for them, which they should, then go for it. Yeah, that's definitely something to post because, you know, the only person who's going to take an issue with it, who has a legal right to sue you, is the company who owns the copyright. So if they don't care about that and they're like, we love it when people copy us, go for it, then there's no issue.
What if it's a huge company like Warner Brothers, but the artist himself or herself loves fan art, but they work for the company?
Yeah, that might be trickier, but I think generally like I would still probably do it because I think, you know, even though the company might take issue with it, like they might have been told from the original creator that like we love this, you know, especially if you feel like the original creator would go on Twitter and like blast Warner Brothers and say like we love fan art, don't take this down and be on your side, then I feel like I'd probably lean more towards doing it, at least until you get a cease and desist letter.
And that's how they would start, right? They wouldn't just like out of the gates like sue you for every penny you've ever made. They would send you a letter first.
Yes, they do send you a letter first. I mean, generally they could sue you, but that's just not usually how it works. They usually send you a letter first. There are some companies, and I've really only seen this with like photos. There's like some stock photo companies that do this, that will send you a letter where they'll be like, you owe us like this usage fee, and it's like a couple $1,000s. I think that's mostly with stock photos. So they could do that, but generally like nobody actually pays those. So I don't anticipate that happening. Most of the time, they just would send you a cease and desist letter telling you to take it down, or they would, you know, report it to like Instagram as a copyright infringement, and Instagram would take it down.
Thank you for that.
Yeah.
Did you find the online, the actual?
Yes. So the actual language is criticism, comment, news reporting, teaching, scholarship, and research.
I didn't hear love in there.
Yeah. I didn't hear it, but you know, it could be comment. It could be a comment on it. It could be a comment on how much you love it.
Right. Commentary. Yeah.
Yeah.
Okay.
And you know, I think like criticism is in there, but like I don't think it should be limited to just like a negative experience with the art. I think it should include positive experiences with it as well.
Mm-hmm. I agree. Okay, Nicole. Okay. Thank you. This has been so enlightening. I need to listen to this episode, even though I just recorded it with you. I feel like now I need to listen to it and take notes.
Yeah, the keynote is that register your important works, register your favorites. Sort of like the opposite of like kill off your darlings. It's like register your favorites, and like copyright is hard. And so if you have a lot of questions on it, like you're not alone. Everybody has questions and everybody has like, I heard this, I heard this, I heard this. So, you know, it doesn't cost that much to have like a consultation with a lawyer and just be like, how do I protect this? How do I, um, you know, how do I register my work? What do I do in this situation and stuff like that? So if you have questions about your specific work, yeah, just ask.
How much is a consultation usually?
Usually, so it's like 150 for 30 minutes, and that's usually enough time to just sort of walk through the specifics of it.
And Nicole, where can we find you?
I'm at sproutlaw.com, or you can find me on Instagram at sproutlaw.
Thank you so much.
Absolutely. Thanks
Are
for
you
having me.
open to people sending you messages if they
Yeah.
have questions, or do they have to pay the consultation fee?
You could send me DMs for like general questions, like what's the copyright website, or like how much is a copyright, stuff like that. But if you're going to ask me specific questions about your work or about a specific situation, then you have to be a client. So I have to have you sign my client agreement and stuff like that, because I can't just like legally be giving people advice about specific situations, because then I get into trouble.
Are you the type of lawyer that you would call if you know you have a case and you need to take somebody to court? Do you practice that kind of law?
I do not. I'm not that person. No, but I can refer you to somebody who does that. But that's not me. I don't usually do that. Most of what I do is just like advising people, sending out cease and desist letters, helping people register their copyrights. But then if you actually need to go to court with it, then you would want somebody who specializes in litigation.
I'm sure questions beget questions. So, please ask Nicole if you need more clarity, and hopefully she can answer you. If not, then $150. There you go. Well, Nicole, this has been so valuable again and so informative. And I just really appreciate you joining us.
Absolutely. Thank you so much for having me. I'm glad it was helpful, and just send any questions my way.
Okay, perfect. At Sprout Law. I hope you have a good day today.
You too. And sorry about the weird drilling noise. I guess our dryer's being repaired at this literal moment.
We all need to dry our clothes, so I understand.
Yeah.
And it's hard to get people to come to your house to work on them.
That
So
is true. Yeah.
you get a pass.
Okay.
All right.
All right. Have a great day.
You too. I'll talk to you later.
All right. Sounds
Bye.
good. Bye.
Please give Nicole a follow. Her Instagram is at SproutLaw, SPROUTLAW. And again, her website is sproutlaw.com. And my Instagram is at Runa Glassworks. Her website is great. She has a lot of incredible blog posts, contract templates, and she even has a free webinar on how to name your business. She also puts a lot of love into her Instagram, and it shows. She posts incredibly informative stuff. That's all for today, friends. I hope this episode was helpful. And if you'd like to toss a tip in my tip jar for today's episode, you're in luck, because you can become a patron on Cracked's Patreon page. There is a direct link in the show notes on all episodes, and I'm currently working on Cracked merch for my patrons. I'm in the logo design and trademarking phase, so don't even try it. Don't come for me. It's trademarked. Next week, Maggie Wilm of Colorado Glassworks. All right, my little cracked heads. Thank you for listening. Bye.